Good afternoon. I'm Ken Marcus, founder and chairman of the Louis D. Brandeis Center for Human Rights Under Law, and I'm pleased to welcome you to our webinar. This is our first webinar on religious accommodations, and we offer it to you as part of our contribution to the National Shine a Light initiative. In this project, as in many others, we are helping to shine a light on anti-Semitism. And we urge those of you who want to know more about how you and your businesses or corporations or other institutions can shine a light on anti-Semitism to check out shinealighton.com. Today, we are focusing on the workplace and specifically on religious accommodations in the workplace. Many of you know us a little better for our work on campus. And as you may know, while we were founded 11 years ago broadly to advance the civil and human rights of the Jewish people and promote justice for all, the fact is we have been focused like a laser on the growing problem of campus anti-Semitism. And to this day, we have pending cases across the country dealing with higher education, from Southern California to Vermont, from New York to Northern California, and everywhere in between. But what we have found is that while campus anti-Semitism is a growing problem, many of the problems that we have seen in higher education are starting to seep into the workplace as well. That is why we have found that in order to deal with the problem effectively, we have to look at it where we go. That is to say, on college campuses, but also in the workplace. We're very pleased that for today's event, we have an outstanding moderator, the Honorable Andrea R. a member of the U.S. Equal Employment Opportunity Commission. Commissioner Lucas is one of the leaders in American civil rights enforcement. I could talk about her impeccable legal credentials, her training at Gibson Dunn, her background at the University of Virginia and the University of Pennsylvania, her legal clerkship. But what I think is most important for you to know is that she is one of the few senior government officials who has really made religious freedom and religious discrimination one of her top priorities, including significantly the battle against anti-Semitism in the workplace. If you haven't already seen the presentation that Commissioner Lucas did jointly with Commissioner Keith Sonderling for the Louis D. Brandeis Center last year, it is on our website, and I think that it is a truly informative presentation. But for now, I'm going to turn things over. At the end, as usual, my colleague Eliza Lewin and I will rejoin the presentation. But for now, I'm very pleased to turn the webinar over to Commissioner Lucas.
Thank you so much, Ken. And I'm so pleased to be here moderating this important discussion about religious accommodation in the corporate workplace. I'm also so glad to see the Brandeis Center leading in this space following its critical work advocating for religious civil rights on college and university campuses. Workplace civil rights, not campus ones, obviously are the focus for the EEOC, of course, but I do think there's a deep connection between on-campus incidents and the culture of our country's workplaces. Our country's top universities often serve as feeders of the next generation of leaders in the highest echelons of corporate America, the government, the media, and other portions of so-called elite society. As a result of anti-Semitism and other acts of religious harassment or exclusion become normalized on campus, that can have grave consequences for how today's entry-level employees and tomorrow's leaders at work understand or misunderstand workplace rights and what problematic conduct they view as commonplace or even acceptable. I'm hopeful today's discussion will be a good step in helping both students and employees understand and value religious rights in the workplace. So I'll turn now to introducing our panelists for today's event, and I'll just proceed alphabetically. First, we have Richard Foltin, who is a fellow for religious freedom at the Freedom Forum. Previously, Mr. Foltin served in a number of senior positions at American Jewish Committee, AJC, most recently as the Director of National and Legislative Affairs in its Washington, D.C. office. And while at AJC, he co-chaired a coalition dedicated to enacting legislation that would be responsible, that would strengthen existing law on workplace religious accommodation, as well as being responsible for AJC's policy development and legislative activities on a wide variety of issues, including religious liberty, civil rights, immigration, and combating domestic anti-Semitism and anti-Israel boycotts. And prior coming to AJC, Mr. Foltin was associated with Struck and Lavin, a New York law firm. He also received the Dorothy Height Coalition Building Award from the Sikh American Legal Defense and Education Fund, and has been Harvard Law School Westerman Public Interest Fellow, a Fellow of the American Bar Foundation, a member of the Executive Committee on the Inter-Jewish Muslim Alliance, and a co-chair of the ABA Religious Freedom Committee. And Mr. Foltin is the child of Holocaust survivors, and he has his BA from New York University and his JD from Harvard Law School, a member of the Bar of New York State, DC, and the US Supreme Court. Welcome, Richard. We're also joined by Etzion Neuer, who is ADL's Director of Regional Operations, and he works with ADL's 4 divisions and 25 regional offices, providing strategic guidance, ensuring implementation of agency-wide priorities and cross-regional collaboration. He has oversight over ADL's incident response system, which is a comprehensive network that I'm sure many of you are aware of, trained specialists who respond and resolve thousands of reports annually of anti-Semitism, discrimination, and civil rights across the US. And he previously, prior to coming to ADL in 1999, was at Hillel Director in Montreal, where he was born. And then finally, we have, last but not least, I should say, we have Arthur Traldi. Sorry, Arthur. Arthur is a senior counsel with Brandeis Center and an internationally recognized human rights lawyer. He served at the International Criminal Tribunal for Rwanda and the International Criminal Tribunal for the former Yugoslavia. And he has worked on amicus briefs, including in the Supreme Court, addressing Holocaust restitution claims. He's a graduate of College of William and Mary and Georgetown University Law Center, also clerked for Judge Zulick and Justice Deborah Todd, and a member of the Board of American Associations of Jewish Lawyers and Jurists, and a past co-chair of the ABA's International Criminal Law Committee. So clearly a panel of experts here, and I'm just so delighted to turn it over to them, and so we can all listen and learn more about religious accommodations in the workplace.
First, I'm honored and pleased to be here as part of this esteemed panel. So let me start at the beginning for just a moment. In 1964, Congress enacted the landmark Civil Rights Act, Title VII, which made it unlawful to discriminate against employees on the basis of race, color, national origin, sex, and religion. However, Title VII in its original form did not explicitly extend to accommodation of religious practice. And there followed a series of what I'll call good news and bad news, enough good news and bad news to almost be a Hegelian dialectic. In 1967, the EEOC issued regulations stating that it was a form of religious discrimination for an employer to fail to reasonably accommodate the religious practices of employees absent an undue hardship upon the employer's business. Unfortunately, that was the good news. The bad news was in 1970, the U.S. Court of Appeals for the Sixth Circuit found that the EEOC's action was invalid, saying that the legislative history made clear that Title VII was aimed only at facially discriminatory practices, a decision that was upheld the next year by an equally divided Supreme Court. And then, in a bit of good news, Congress enacted a religious accommodation amendment to Title VII that tracked the language of the EEOC regulation. That enactment is lovingly known as Section 701J. And Nat Lewin, who was originally slated to speak on this panel, played a key role in the crafting of that amendment. And here I'll deliver a shameless plug. You can hear that story. The story of how that provision came to be in Title VII in the recording of an ABA program on religious accommodation in which Nat and I recently participated. 5 years later, there followed yet again bad news. The framers of 701J were greatly disappointed when in 1977, the Supreme Court decided in Hardison v. DWA in a Sabbath accommodation case that anything more than a de minimis cost to an employer would be an undue hardship for purposes of Section 701J. Well, on my first day in law school, they taught me that de minimis means ain't much. So it soon became clear that it wasn't much of a difficulty or expense that had to be found in order for an employer to be absolved of the obligation to provide a reasonable religious accommodation. Thus, in TWA against Hardison, the court found that TWA was not required under Title VII to incur any costs, either in the form of loss efficiency in other jobs or higher wages in order to give the plaintiff Saturdays off. In his dissent in Hardison, Justice Thurgood Marshall, joined by Justice William Brennan, asserted that the court in effect was saying that in enacting 701J, Congress did not really mean what it said. Justice Marshall said, as a question of social policy, this result is deeply troubling for society that truly values religious pluralism, cannot compel adherents of minority religions to make the cruel choice of surrendering their religion or their job. The court's reading of 701J, in particular with the de minimis interpretation of undue hardship, so vitiates the obligation to reasonably accommodate as to result in effectively nullifying it. It should be noted here that part of the reason the majority went the way it did was that they were concerned about possible violation of the Establishment Clause by requiring employers to provide religious accommodation. And the irony here is that the dissenters were Justices Marshall and Brennan, who were the most stalwart defenders of the Establishment Clause historically, much more so than many of the justices in the majority. So if there really was an Establishment Clause problem, I would have expected that Justices Marshall and Brennan would have been very much aware of it. It's not only a definition of undue hardship that is problematic, so also is the fashion in which many courts have addressed the question of what is a reasonable accommodation. One might expect a reasonable accommodation to be one that actually removes the conflict with religious practice, leaving to the undue hardship prong resolution of whether that is more than an employer can be expected to do. Cases, however, in which courts have suggested that an accommodation of religion may be considered reasonable, even where it forces an employee to compromise religious beliefs or face termination. For instance, courts have held that employees' rights under collective bargaining agreements or other quote-unquote neutral shift allocation procedures are in of themselves reasonable accommodation. Well, it should be immediately obvious that if your idea of a reasonable accommodation is that an employee only has to work on one Saturday out of 4, that employee, if he or she is a Sabbath observer, is going to be out of a job on that 4th week. So it's really not a reasonable accommodation at all. It may be an undue hardship. As I said, that's the prong you have to look at. To say that you can have a reasonable accommodation that nevertheless fails to meet the religious need of the employee is just a contradiction in terms. Compounding this problem is the fact that, and this goes back to Hardison, it's really quite interesting that the TWA was joined in its opposition to providing accommodation by the collective bargaining unit that Hardison was part of. In other words, the union did not see it as its obligation to attempt to arrange for an accommodation of a religious practice, but instead stood in the way of doing so. And that has been a problem. And one of the I think salutary changes over the years is that unions have become much more oriented towards seeing that as part of their responsibility than they were in those days. But that was a problem during the Hardison years. By the late 1980s, the problems posed for employees by the court's reading of 701J had become evident. Behind every denial of accommodation was the story of an American forced to choose between their livelihood and their faith, with those who put faith first often suffering catastrophic losses, including their homes, access to their health insurance, their ability to help their children through colleges, even impact upon their marriages. It was evident then, and it is evident now, that without better decisions by the courts or some kind of a legislative relief, this is going to continue to be a problem. As a result of this, and this is where I came into the picture personally, when I came to AJC's legislative office in the early 90s, I began to work with Jerry Nadler's office, with David Lackman and Jerry Nadler's office, and with Gary Ross, the then legislative director of the Seventh-day Adventist General Conference, on working on a bill and organizing a coalition to promote remedial legislation which would strengthen the religious accommodation provisions of Title VII. That bill was introduced on a bipartisan basis in 1994, and then in several Congresses thereafter, up through and including the early 2000s. The principal things that it did was it would have redefined undue hardship to mean involving a significant difficulty or expense. This was picked up from the Americans with Disabilities Act, which itself, interestingly enough, the way the Americans with Disabilities Act was written was to provide for a stronger definition of stronger protection providing religious accommodation, because the drafters of that bill recognized the problem that had occurred under Title VII vis-a-vis religious accommodation. So we were seeking to return the favor and pick up the definition then from the ADA. Also, the bill, among other things, would have said that to be a reasonable accommodation, you have to actually resolve the conflict with, again, any questions about problems for the employer being left to the undue hardship prong. In those halcyon days, the bill had bipartisan support, had a backing of a broad multi-faith left-right coalition, and there were several hearings in both the Senate and the House. So I'm just going to wrap up by saying, as is evident to anyone who works in this area, there is no bill, there was no bill enacted, there is no Workplace Religious Freedom Act, and that was because initially we had what I would call two small problems, business and labor. Business basically was saying the current system is working well, there's no need to add the substantial burden that employers already carry. Labor was concerned about whether or not the Workplace Religious Freedom Act would run afoul of 703H of Title VII, which provides that a bona fide collective bargaining agreement shall not be considered to be a violation of Title VII. Our coalition reached out to labor and sufficiently comforted their representatives that nothing in the bill was purporting to override 703H. And while labor did not endorse the bill, they never came out in opposition to it. However, by the time of a 2008 House hearing on WRFA, our former supporter, the ACLU and other groups, had begun to urge that the bill not move forward because, as they saw it, it would, among other things, protect harassment of LGBTQ people in the workplace in the name of religion, and that accommodations under WRFA would also be used to limit access to reproductive health care. To be sure, not all pro-choice or pro-gay rights supporters of WRFA walked away over that issue. I testified at the time at a congressional hearing that nothing in WRFA's change of definition would alter the fact that the courts had consistently recognized workplace harassment as a significant hardship for employers, and also that the courts would find it a significant burden to have to provide an accommodation that had made it impossible to provide the care they were in the business of providing. As a footnote, I'm not so clear today that I would be so sanguine about the courts, but that's how I saw it back then. In any event, the bill began to lose the support on the Democratic side. We tried to develop a targeted bill that would have addressed only such non-controversial accommodations as time off, grooming, and dress, affording those practices enhanced protection. But that raised problems on the right. That is to say, folks on the right were saying, well, you're treating our concerns less serious than those concerns that are such as time off, grooming, and dress. We want at least to have our day in court to make a case for why our concerns ought to be addressed in terms of not having to perform duties that are inconsistent with our religious beliefs, etc. So with all of that, for about the last 10 years, legislative efforts to amend 701J have been dead in the water. But that's not to say there haven't been recent developments in the courts, not the least of which is the Supreme Court's decision in EEOC versus Abercrombie and Fitch, and that you're going to hear about from one of my co-panelists in just a few minutes. So thanks very much, and with that, I'll conclude my remarks.
Thank you very much, and thank you, Ken and the Brandeis Center for including ADL on this panel. Listening to Richard and even Ken at the beginning, I'm struck by just how much of what we take for granted is owed to the work of attorneys like Richard and the Lewins, to organizations like the Brandeis Center who fought for religious rights, in particular Americans of faith who wish to participate in broader American public life and can do so without having to sacrifice core values and beliefs. Unlike other distinguished members of the panel today, and much to the deep sadness of my parents, I'm not an attorney, and I'm going to leave the strict matters of the law up to those experts. I'm going to try to use my time today to talk a bit about ADL, our approach, and how we bump up against religious accommodation issues. I'll close with some observations on developments in corporate culture in response to racism and anti-Semitism, and how that's affecting religious employees, and in particular Jews. First, for background, ADL is the leading anti-hate organization in the world. Our mission, which was created in 1913 and hasn't changed, is to stop the defamation of the Jewish people and to secure justice and fair treatment to all. And today we continue to fight all forms of anti-Semitism and bias, using innovation and partnerships to drive impact and ensure a just and inclusive society. In my own 23 years with the organization, a significant part of my role has been working with the public or training our staff who play that role. ADL has some kind, if you go on our website, you'll see we have an intake form where constituents can report an incident. Essentially, they're basically people asking us for our assistance. And we've seen a dramatic increase in the number of years from reports that are coming in. There are thousands of these reports that come in every year. And from that big mass of reports, there is a smaller subsection that would fall into the realm of religious accommodation. In general, most of the common inquiries that ADL receives about religious accommodation are around conflicts with calendar issues, schools, or housing. On a personal note, and even as a non-attorney, working on these types of cases and advocating for religious rights have always filled me with a deep sense of gratification. I come from a religious family. My own grandfather, my late Zadie, immigrated from Poland in the 1930s. And like so many immigrants, he struggled with holding down a job because of his religious observance. And even so, decades later, while the landscape has changed and improved so dramatically, ADL still does get complaints about the corporate space. And typically, those complaints are about employees who are being asked to work on days that conflict with religious holidays. Now, we do have skilled, trained attorneys, unlike me, who can advise our regional staff, but obviously, depending on the facts, we generally don't lead with a legal approach. We use an approach that combines some kind of a blend of advocacy, communal relations, equity, and an appeal to the company to ultimately do the right thing. We've learned that a lot can be accomplished with a polite phone call from ADL, and in some cases, we'll write a letter on behalf of a constituent. While so much of our work ends up in the news, when it comes to incident response, most of the work we do does not end up in the news. It's actually below the radar screen. So who reaches out to us and why? There are plenty of people who will immediately contact the lawyer and Gesundheit, but there are so many others who fall into a different category. Maybe something happened to them at work, maybe something is happening, maybe they don't know if laws have been broken, so they're not sure if what's happening rises to the level of discrimination. Many times people are afraid, they're afraid their job might be threatened. They might be anxious about bringing in a lawyer. They might think that their workplace will interpret that as an aggressive tactic, and they're afraid it's going to affect their job security. And this is something that I had to learn early on because I was amazed that some people actually don't know any lawyers, or they worry that they can't afford an attorney. Oftentimes people are looking for someone they can talk to. They want context for what they've experienced. Is their situation really problematic? Are they being oversensitive? So they reach out to us. The nature of ADL's work is, because it is so responsive to world events, there's a strong element of unpredictability to how any given day will play out. But if there's one complaint that's reliable, it's that every fall, some of our offices are going to be hearing from some public school teacher asserting that the school calendar discriminates against them on the basis of their religion. Like most employers in the US, most school systems, public school systems, are closed on major Christian holy days, but they are open on the holy days of other faiths. Of course, schools do this because they sort of game the school calendar so that most major Christian holy days coincide with school vacations. But what happens when an employee who isn't Christian has to use personal days for religious observances, or they have to take unpaid leave for those days? Is this discrimination on the basis of religion? Consider this past September, October, when an observant Jewish person would have missed 7 work days. I'm going to leave it to the lawyers on this panel who will cite case law and Title VII, but as appealing as this argument might appear to the teacher, the details of what's considered reasonable accommodation means that we're probably going to have a tough conversation with the teacher and come up with some alternative strategies. Focusing a little bit more narrowly in the corporate space, increasingly, more and more companies recognize that creating and managing a diverse workplace is not just the right thing to do, but it's essentially a business imperative now for organizations who want to be competitive and successful in the marketplace. And in the last few years, DEI initiatives, DEI, of course, is diversity, equity, and inclusion. These initiatives have popped up in companies, but we've noticed, because we've heard from constituents, that some companies are overlooking religious diversity as part of their broader DEI programs. And here's how it manifested for us. Here's how we spotted that this problem was happening. In June of 2021, when anti-Semitic violence surged here in the US, our offices started hearing from Jews who were working in the corporate workspace. They were, of course, deeply concerned about the anti-Semitism that was happening around them. But what was making these folks particularly troubled was something new, something we actually hadn't seen before. What they were telling us was, after the murder of George Floyd, they saw and they appreciated the corporate statements, solidarity with the Black community, and these statements were often accompanied with pledges to advance racial justice and equity. And about a year later, when they saw horrific racist verbal and physical attacks directed against Asians, Asian Americans, and Pacific Islanders, they received similar sympathetic statements from their employers. So it's June 2021, and anti-Semitism is spiking, and they were hearing crickets from their companies. And when the brave few who poked their HR departments or DEI offices, they were at best disappointed with the results. Most heard nothing. And what became obvious to us was that in a rapidly changing workplace, these DEI departments were largely unequipped to deal with religious diversity. And with anti-Semitism rising, DEI professionals must ensure that addressing anti-Semitism and cultural competency on Jews and Jewish issues is part of a workplace DEI strategy. To build a more inclusive workplace, DEI efforts must take into account the experiences of all employees and do so in an intersectional way. Otherwise, we risk failing to address the gaps and inequities that keep us from creating truly inclusive workplaces where all people can thrive. To address the gap, ADL is drawing on our expertise in anti-Semitism education, and we've developed training to incorporate anti-Semitism and other issues impacting Jewish employees into DEI strategies. Inclusion means that every employee feels safe, welcome, embraced, and empowered in an organization. As anti-Semitism rises, Jews' perceived and real safety declines. We work with organizations to provide support and materials and training sessions with experts on anti-Semitism and anti-bias topics. Whether it's through conducting training or developing employee resource groups, they're called ERGs, for Jewish staff and allies, reviewing internal practices, policies, language, manuals, or updating a company's internal calendar, companies can do a lot to address Jewish issues. I cited my grandfather who had trouble finding a job because of his faith. With that in mind, and even with troubling hate rearing its ugly head, it is difficult for me to look back and not be somewhat optimistic by how far we've come in making changes to the law so that all religions or people with no religion are welcomed, valued, and included. That only happens because people who care and organizations like the Brandeis Center do something about it. I would encourage everyone here not to be content with just being knowledgeable about the law, but to also be advocates for justice. Thank you.
Thanks, Etzion. That's a great transition. And thanks to Commissioner Lucas and Mr. Foltin for being with us as well today. This is a great panel, and we're excited to have everybody. And I'd encourage you to put questions for us in the Q&A box. I'm going to talk about two main things. First, picking up where Etzion left, the trajectory that we've found the law is going. And second, some things companies can do. So first, the direction that we've found the law is going. I don't think it's any secret to anyone that litigants bringing claims based on legal protections for their faith have had as much success at the Supreme Court recently as at any time in memory. In litigation against government authorities, people of faith have won cases for including religious flags in a public display, cases that ensured religious belief would get exceptions from generally applicable laws if officials had discretion to grant any other exceptions, and cases guaranteeing equal access to government support for some faith-based projects, including sectarian education in Maine. Now, those are cases against the government under the Free Exercise Clause, and what we're discussing today is the private sector corporate workplace under Title VII. So I don't want to overstate the importance of those cases in a context where business litigants have also been very successful recently. But I would argue that those free exercise decisions matter, and they inform what we reasonably expect the court to do. One way we see that is how the court has explained them. In Kennedy versus Bremerton, for instance, the majority wrote, "The Constitution and the best of our traditions counsel mutual respect and tolerance, not censorship and suppression, for religious and non-religious views alike." And it continued that the law protects not just the right to harbor religious beliefs inwardly and secretly, but that it does perhaps its most important work by protecting the ability of those who hold religious beliefs of all kinds to live out their faiths in daily life through the performance of or abstention from physical acts. For many people, particularly those from minority religions, because a lot more places close on Christmas than close on Yom Kippur, one of the essential ways that their faith calls on them to abstain from physical acts they would otherwise engage in is by saying when they should refrain from work for religious reasons. So if we're taking the rights of people of faith to live out their faith in daily life seriously, that means taking Title VII's protections for religious practice seriously. Commissioner Lucas put it this way herself in a speech back in May. She asked, as a practical matter, what good would it be to many people of faith if the government does not infringe on their right to free exercise, if freely exercising their faith means that they effectively cannot pursue their career of choice, or worse still, cannot hold a job because of the policies and actions of private employers? I believe, she said, the private sector has tremendous influence over religious liberty and therefore has a significant role to play in promoting and protecting religious liberty. Of course, as she went on to explain, with these great responsibilities, with this great power to influence whether people can live out their faith, the law has imposed responsibilities on employers. And the direction we've found that the law is going is to take those more seriously as well. In 2015, the Supreme Court heard a case about a Muslim woman who was denied a job at Abercrombie and Fitch because they thought she was going to wear a head covering and violate their look policy. And the Supreme Court found Title VII gives religious belief favored treatment, obligating employers not to fail or refuse to hire or discharge any individual because of such individual's religious observance and practice, and added Title VII requires otherwise neutral policies to give way to the need for an accommodation. And I think it's worth mentioning here, Abercrombie and Fitch, of course, is a clothing store. They can plausibly say they're selling a look. If they can't deny an accommodation for religious attire, it's highly unlikely any employer would be allowed to do so unless they could show that that religious attire raised a safety issue. And we've seen cases, too, that address explicitly some of the issues Richard mentioned. For instance, courts have recently held that an accommodation that doesn't fully resolve the conflict between an employee's obligation at work and his religious obligation is presumptively not reasonable. That it can only be reasonable if there's an undue hardship that would arise if the conflict was fully resolved. And we've seen regulators are taking that message too and telling employers to do more. We note in our recent fact sheet, and I'll put that in the chat, that both the EEOC and the Office of Federal Contract Compliance Programs have issued new religious accommodation guidance in the past 2 years. I think the changes are very informative, and I want to be clear that these were part of broader updates. The EEOC has also addressed things like anti-discrimination policy and the ministerial exception, and much of the discussion of them was about those issues. We're only focused on accommodations today. But the EEOC's new policy, for instance, makes targeted changes that I think make a difference. And one example is it gives a lot of examples to illustrate when accommodations are and are not required. And in almost all of those, the outcome, that is whether an accommodation is legally required or not, is the same as it was under the previous guidance. One outcome changes, and it's example 33 in their guidance, where it previously said that an accommodation could be denied if it posed an undue hardship, and now says even if the employer shows an undue hardship, it must grant the accommodation to the extent that it can do so without an undue hardship. That is, the law requires it to do, the EEOC is saying, everything it can that doesn't trigger the undue hardship defense. So doing nothing isn't an option. And of course, EEOC is clearer in its new guidance that employers need to prove an undue hardship through evidence, instead of just saying, hey, this is going to be difficult. That's not enough to get out of Civil Rights Act requirements. You need evidence. And that's also a theme of the new OFCCP guidance. OFCCP regulates companies that it says employ about 20% of the workplace that are involved in some way in federal contracting. And they really expanded their accommodations guidance, which is about twice as long as it used to be, and make really clear that an employer needs evidence. I'm going to read the key sentences of the new guidance because I think they're important and illustrative. They say an undue hardship can only be demonstrated by specific, concrete, clearly ascertainable impositions on the contractor's operations. Hypothetical or speculative costs and burdens, where the harm to the contractor is indeterminate, do not constitute undue hardships. And they add that an undue hardship has to be immediately present or likely to occur and impose actual costs or create an actual disruption. An anticipated cost or burden doesn't do it, and one where the contractor can't show a financial cost, they say, will generally not suffice. Taking those together, I think the conclusion is clear, which is that the legal landscape is continually improving to incorporate the best of our traditions and to allow people from minority religions, particularly, to live out their faith in their daily lives while minimizing the situations where it can hurt them in their professional lives. Now, when I say continually, I don't necessarily mean TWA versus Hardison will go away this term, although I think we'll hear a little bit more later about a cert petition requesting just that. But a court doesn't have to overrule a case to narrow it. And if I were corporate counsel deciding whether I was confident that a case was on all fours with Hardison, or whether I thought there was a risk that the court might distinguish it from Hardison and other precedent in a way that led to the employee winning, I'd definitely take this trend into account. Smart employers are addressing this. Some of the ways Etzion described, for instance, facilitating Jewish employees' full inclusion by setting up employee resource groups, setting up systems to handle accommodation requests, letting staff know about the process, training employees in management to review requests in ways that are in compliance with the law. OFCCP has some good best practices on this that I'll put in the chat in a moment. But the big thing that companies can do for employees right now, of course, is, as Ken mentioned, to join the Shine a Light campaign against anti-Semitism around the Hanukkah holiday this month. It's a great campaign with dozens of companies and other organizations, and we're honored to be part of it this year. And they too have some great resources for companies that are looking to be more inclusive of their Jewish employees, including, I'm proud to say, our Accommodations fact sheet and some of our other work, and a great resource on accommodation from Etzion and his colleagues at the ADL, who are also partners. If you're with a company and want to get involved, you can contact any of us here at the Brandeis Center. I think that's a good note to finish on. So thanks for your attention, and I look forward to your questions.
For our audience, feel free to put any questions you may have in the Q&A function. Sorry, I mentioned to put it in the chat. That was not right. Put it in the Q&A functions. And I see we do have one question, but I believe Ken and Elisa were perhaps going to jump in initially, or I'm happy to address the one question we've got so far.
I'll yield to Elisa, especially since I know that she has a comment from someone who was not able to participate today.
Sure, my father. Thank you, Ken, and thank you, Commissioner Lucas, and thank you, first of all, to all the panelists for really wonderful presentations. So my father, who was unable, unfortunately, to join us today, had sent a comment specifically about the current case that the current cert petition that is pending with the possibility of overruling the TWA versus Hardison case, which Arthur mentioned, with Richard, I think also referred to. And so I just wanted to read what he had sent here. So he asked me to deliver this message, that the Supreme Court has on its docket today a case that can make a very big difference in this area and can overrule TWA versus Hardison. That case is called Groff versus DeJoy. It's actually number 22-174. He says there have been 14 friend of the court briefs filed asking the court to take this case and overrule TWA versus Hardison. The Department of Justice has filed an unfortunate brief opposing the granting of certiorari on the ground that this is a, quote, poor vehicle, close quote, for taking this action. The court will shortly decide whether to take the case, and since the objective of the petition is to overrule a Supreme Court dictum that has harmed hundreds and possibly thousands of religious observers, it makes no sense to say that an opportunity to overrule that dictum is a quote unquote poor vehicle. 3 justices of the court have already opined that TWA versus Hardison should be overruled. Hopefully a 4th justice will concur, and this terrible precedent that has harmed so many religious Americans, including Sikhs, Muslims, Jews, and Sabbath-observing Christians, will be eradicated. That's my father's comment, and one of the key points that he thinks we're at right now in terms of judicial precedent.
I have a question for Arthur, if I may. And to his chagrin, this was not even remotely planned in advance. Arthur, you have mentioned a few times the new Brandeis Center fact sheet on religious accommodations, and a link appears in the chat section. This is not the first fact sheet that anybody has ever put up on the internet about religious accommodations. What could you say about what's new or different in what we've just published?
So I think the biggest thing is the focus that was at the core of my presentation today on the direction of the law. And I think that takes two forms. The first is thinking about how religious accommodations requests today fit into the trend of the law on religious freedom in the United States generally. But second, and I think this is consistent with the Brandeis Center being an organization founded by a former senior executive service member in a regulatory agency, is a significant level of attention to new regulatory guidance, not just judicial precedent, but guidance from the agencies that shapes and that immediately directs employers how to respond to requests like this in their day-to-day work.
Thank you.
We have a question about a beard, and that made me want to flag one point before turning this question over to Arthur, because you had mentioned, what to do about safety issues, for example, look issue versus safety or other considerations. But in response to the commenter, the questioner noted, what about a beard? My father worked in the U.S. Army Corps of Engineers and had a problem keeping a beard in the 70s and working later. Just wanted to flag for everyone that the EOC recently filed a very interesting piece of litigation that you should follow, a significant beard accommodation, a case involving the requested use of PAPRs, purified air respirators, in the context of COVID and pre-COVID periods of time, and just demonstrating how it can be a universal issue. The 6 plaintiffs are from a wide variety of faiths. We have an Orthodox Jew, we have a Norse paganist, we have a Baptist, a Hebrew Israelite, a Sikh. So really a big group of people all asking for the same accommodation. And of course, there will be, I'm sure, pushback related to safety, but the agency thinks, and I agree, that there's a good case to be made that there was ways to balance this with an alternative method of addressing the same level of safety through a PAPR versus an N95, which was the requested by the rule by the employer, which of course N95's fit can interfere with facial hair. So something that people should be watching. Their first sort of initial data point. But Arthur, other things that you've seen sort of the beard space or safety issues?
I think Etzion may have had his hand up, so I'll
sure.
defer to him on that one.
Right, I perked up on this case because Commissioner Lucas, I appreciate what you were saying, and also that you brought in this. I'm going to make an assumption when I see someone with a name like Yaakov. I'm going to take an assumption that we're talking about someone who was doing it for Jewish religious reasons, but you brought in it by talking about the Sikh faith and also a couple of others. You talk about, we don't think often about the pagans, but there's just something else to think about too. Is that companies often we would encourage companies. There's that sort of this level of what we consider to be sort of tolerance, right? And a word that some of us flinch at, and we might accept tolerance but at some level, sometimes that's sort of like the lowest threshold. But we would push companies to go beyond tolerance when it comes to some of these policies, and that when if companies are sometimes not aware of personnel who follow religious apparel or grooming requirements, we tell them, don't assume that just because you don't have employees who don't have beards, that's because they don't want to follow these laws. They don't want to do this. Many of them aren't aware that they can do it, and there's this sense also that if they think that it's going to take an exception for them, if it's going to mean upsetting someone or it's going to be difficult for them, they may hold back and suppress their own religious inclinations. And we would encourage companies to look at these policies and say, like, we encourage employees, or we welcome employees to have who wish to have unshorn beards, or these different sort of grooming requirements of different faith religions, right? That includes women who cover their hair, whether it's Orthodox women who wear wigs, or Muslim women who cover their hair cover themselves with hijabs. So again, companies can do a lot in this area.
Richard, I
I
think
could-
you're on mute.
Yeah. So couple things. One is, and I realize this has to do with public employees, so you get the constitutional element involved as well. But there's a case quite a while ago which stood for the proposition that the New Jersey Police Department had to allow members of the force to wear beards for religious reasons if they were allowing beards to be worn because of medical reasons. And now, this is currently a big controversial issue in terms of to what extent you can invoke medical exemptions as a basis for religious exemptions, but the law is certainly trending in that direction. And so I would not take for granted that because an employer doesn't want to allow it, whether it's for when it allows beards for medical reasons or because they have a looks policy, and I'm thinking about Abercrombie and Fitch, that the kinds of things that have been invoked in the past to deny the ability to wear a beard or to wear certain kinds of clothing is that nothing is yet set in stone, but I think the trends are in the right direction in terms of opening the door to accommodation. In addition, and this goes back to I think the point that was made earlier about the steps that you have to go through when an accommodation is requested. We're seeing in the COVID cases now, even though employers generally have quite wide leeway in terms of doing things to protect the health of their workforce and of their customer base, you have cases that are saying you can't simply come in with a generalized objection. You really have to step forward and engage in the process with your employees of seeking an accommodation, and you have to show particularized and individualized reasons why you can't work out something in this context to both honor the accommodation that the employee is looking for and at the same time protect the interests that you want. So there are no slam dunks in this business. That's what keeps lawyers employed. But I think the crucial fact is that the law is trending in a good direction, and the employer's obligation to truly engage with the employee and seek a way to work things out is an imperative. A lot of cases are being lost by employers because they simply didn't go through the steps that they should have gone through in order to assess the request.
Process matters. That's absolutely true. You can't short circuit this process, and an individualized assessment is so important. We have two questions I think sort of overlap. The question of what to do when rights conflict. Always a tough question. One commentator notes, what do you do about the insistence in New York that one not misgender those identifying as trans versus a woman's right to an accommodation, including for the purpose of using a mikvah, for example. And another commentator notes, how to balance rights for sexual orientation versus religious rights. For example, baking cakes in a same-sex religion, a same-sex wedding, and asks, what side of the law should religious Jews be on?
Well, let me rush in where angels fear to tread. I think these are first of all they're very hard questions, and there's not going to be a one-size-fits-all response. The question about the cake bakers, well, in another context, this very morning, the Supreme Court heard arguments in the 303 case, which has to do with whether or not a website designer is obligated to design the website for an upcoming same-sex marriage when they have religious, well, in this case, it's a free speech objection to having to do so. The courts are going to have to weigh these things. And the question, first of all, where should a Jew, religious or otherwise, fall out? I don't think there's one answer to that. I think that Jews come from a variety of backgrounds, religious, political, different perspectives on how you balance these contending interests. We're dealing with interests that are vital to us as Americans on both sides. We should be against discrimination, against people being denied a place in society because of their religion, their race, their sexual orientation, other invidious categorizations, and we should be for preserving religious freedom. And the challenge is to do so to the fullest extent possible, and sometimes these interests aren't correct.
Maybe the thing I'd add to Richard's wise words on this is to just take us from that first example about the business back to the accommodations topic of the webinar. And I think one of the things that makes that first case, the case about the cake, really hard is that you have two very strong competing interests, right? On the one side, you have someone's right to an equal participation in the public sphere based on their definition of their own identity and to equally receive services based on the definition of their own identity. On the other hand, you have religious freedom, an honored tradition in America. But when it comes to requesting an accommodation in the workplace, both of those cut in the same direction. Both of those favor the employee. And so there are other very hard religious freedom cases, in part because those things may come into conflict. But these, I'd suggest, both of the weightiest issues wind up cutting the same direction, both wind up cutting in favor of the direction that we see the law going.
Can I see you have your hand up?
First, I want to emphasize, as Elise Lewin did, what a fantastic panel this has been. So I also want to thank the moderator and the panelists. I want to get a sense, especially from Richard and Etzion, on an issue where I think I got a feel for Arthur's answer. When the panelists have spoken about the history, we've heard both progress, but also obstacles and some limitations. When we've heard about the very recent situation and the current day, we've heard about recent successes, both in the courts and also in the executive agencies. Are you optimistic for the future? Would you agree that the trajectory is moving in the right direction, both for the courts and the executive agencies? Or do you have concerns either about whether the administrative decisions that we've gotten over the last few years might not have staying power, or because the Supreme Court might not react as favorably as some hope to some of the challenges that Nat Lewin and others have discussed?
I'll jump in just to start, and I will guarantee, and as is consistent with people who know me, I'll provide you with a very unsatisfactory and disappointing answer, and that is that I'm conflicted. But I think there are reasons to be optimistic, and there's reasons to be deeply concerned, both in terms of trends and the things that I'm concerned about are the things that have been aired by me and by others on this panel, and even less in the legal sphere. But I'm talking about what's happening in society around us. Is that because I've had a relatively long career at ADL, and one of the sort of the rueful jokes that I get all the time is that you work for ADL, you have great job security, right? And it's this terribly piece of black humor. But when I started and where we are now today, there were people over my career, times in my career, when people would tell me, like, what do you do? What are you guys doing? Like, there's not a lot to do. I mean, I knew that wasn't the case. And yet what part of what has changed now is that I think there's a recognition, look, some things really objectively have changed. And I think also that people recognize some of the deep problems that we have. So I think on the one hand, there's parts that I'm deeply concerned about what's happening. At the same time, I think when we look and see not just where the Jewish community is, but where we see where government is, where we see leadership and organizations, indeed organizations that are represented here, and the way people are going and thinking about and grappling with these things, I think we're seeing a community that is maturing and able to grapple with these issues in a way that still leaves me with great hope. If I didn't have hope, I promise you, I have no business doing this work. I should not, because after all, what I'm doing is trying to create a better future, and I believe that we can do it.
Yeah, I agree that I think certainly in terms of the issue of accommodation in the workplace, I think there's a long way to go yet, but I think we're moving in a salutary direction in terms of where the courts are going and where employers are going. There's work being done by Brian Grimm in terms of making the workplace a more welcoming place for people of faith, while at the same time assuring that people who don't share the faith are not being faced with harassment or other kinds of coercion in terms of what their practices are. So I think that's a good direction. The question really is, and here this came up in argument on not on Title VII, but on religious accommodation generally, and the question was whether the infamous Smith case should be overturned. It was Justice Barrett who said, well, if we're going to overturn it, what are we going to replace it with? We have to be very clear on what the standards are going to be. We'll have to be very clear how we're going to deal with accommodation requests in that case. So I think that there's still I think there's still questions that we're going to have to deal with. The court's going to have to deal with, employers are going to deal with, in terms of what does accommodation look like, and how do we do it in a way that's fair to the entire workforce. Those questions are always going to be out there.
Thank you, and thank you all. We are now at the 60-minute mark. So Commissioner Lucas, I want to thank you for your fine job of moderating. And to Aliza and our panelists, I want to thank you as well. For our audience, we will have additional webinars coming out, including another one later in this month of December. So keep your eye out for the brandeiscenter.com website. We look forward to seeing you next time. Thank you all.